Good morning, good afternoon, good evening to all the respected dignitaries, distinguished speakers, honorable participants, and the loving audience, all beautiful people present here from all around the globe. I, Miss Nada Ratkovic, the IIU co-founder Europe, the president of Research Center, IIU, board member and country director Croatia, welcome you all to the first Technical Symposium on Intellectual Property Rights 2023, the day two on the theme Ideas to Intellectual Property Rights IPR. The event from coming 5 day symposium today, we are on our second day jointly organized by International Internship University, IIU Research Center, Tapar Institute of Engineering and Technology, Patiala and Eureka Prize Problem. With me in this great technical symposium is a great Dr. Sovi Ganguly. He is our co-organizer. We are making this wonderful event. Yesterday, first day. Today, we will have an amazing, estimate, great expert, new expert today. So let me just shortly introduce our organizer, International Internship University. We are here on the platform, on the big stage of IIU. We know that IIU is a leading virtual education system and global brand confederation and most valuable and trusted worldwide. Very well reputed under the strong leadership of Sir Mr. Piyush Pandit, a committed and inspiring social activist. Here, great Dr. Soik Ganguly is coming from the Tupper Institute of Engineering and Technology. And yes, Tupper Institute is one of the oldest India's and finest educational institutions and is providing a steady source of highly skilled talent to the nation as well as overseas. Our great Dr. Soik is an example. He is a great representative of this institute, and we have Eureka Prize Problems. Also, founder, our great Dr. Sovik. And here in Eureka, the objective is behind developing a society promoting research ambience amongst the UG students, undergrad students through organizing competitions, expert talks, seminars, webinars, technical sessions, and encouraging students to write research articles. Me, Professor Nada Ratkovic, as a president of a research center, a unique hub, and giving opportunity to the researchers, authors, educators, students, scholars across the globe, and we are giving research opportunities, academic excellence, real-world problem solving, and knowledge creation and dissemination. Today I need to say, coming from Europe, co-founder of IIU Europe, celebrating Europe Day. So before we start, I want to say Happy Europe Day and Happy E-Twinning Day to all Europeans here. And especially, I want to thanks to our great founder, Sir Piyush Pandit, to our great CEO, Dr. Snikta Kadam, for also promoting Europe, because here at the strong IIU, there are so many Europeans working here on the university. But let's now learn together about intellectual property rights 2023. We will again explore diverse and gain international experience, skills, and knowledge. Today, first and foremost, I want to introduce my dear and respected speaker expert from India. He is well known, Dr. Vivek Arya. Dr. Vivek Arya is working as an assistant professor in the Faculty of Engineering and Technology, Gurukula, Kangri, deemed to be University Hardware, India. Dr. Arya is a convener of Innovation Cell of Gurukula Kangri, also acted as a NSS program officer at Faculty of Engineering and Technology. He did PhD on leaky wave antenna and completed MTech in electronics and communication engineering, along with a gold medal and qualified the UGC NET exam. His research interests include digital image and video processing, optical communication, biosensors, adaptive signal processing, SIV, satellite and radar-based antennas. He has authored one international book on image compression techniques using MATLAB and also published many chapters in international books. He has patented 9 inventions national level and also at the international level published more than 35 research papers in reputed journals IEE, Springer, Wiley, and MDPI and serving as a reviewer in many journals of international repute like Wiley, VCA's, Transactions, IGI, Global Springer. He has delivered various talks for different universities at national as well international level. He has participated in more than 130 conferences, FDPCs, workshops, STTC, and webinars national and international level. He is also helping many institutions and universities of India for research and innovation and IIC-related activities. Apart from this, he is engaged in various social services like Clean Ganga Drive, arranging free medical camps and providing free education for financially incapable students. A big clap for our great Dr. Vivek. You are amazing. And today, here, he will present his topic, Role of IPR in Academia and Industry. Welcome, great Dr. Vivek. IIU stage is yours.
Thank you, Professor Nada.
And we are
And give me
really
just few
honored to have
seconds.
a
I'm sharing my
young,
screen.
great inventor with so many patents, inventions, and our great Dr. Soik is supporting you a lot. And thank him.
Okay, fine. My PPT is visible, I think. It is visible?
Yes, if you can
Yeah,
put
okay.
a full screen.
Okay, ma'am.
Okay.
Vivek, you can put it on slideshow.
Yeah. Honorable
Dr. Soik, please few words before Dr. Vivek starts. Let us hear you today.
Yeah, good evening, ma'am. Once again, good evening to the participants and the listeners in this Facebook live session. We welcome you all for this second day, and we have with us Dr. Vivek. Vivek is a well-known researcher and making some good innovations in IPR industries. And of course, he will deliver a talk on role of IPR in academics and industries. I think our listeners, our participants will be enlightened by his speech. Over to you, Vivek, for your presentation.
Thank you, Dr. Soik. Yes, they will be really enlightened.
Honorable, the founder, Dr. Piyush Pandit, sir, the founder of IIU University. It's a unique kind of university in the world. Respected Professor Nada, ma'am, and a very dynamic professor from Thapar University, and all the dignitaries who are attending this event from virtual platforms. Good evening to all of you. Today, I'm going to discuss few key advantages or key significance of IPRs in academia and industry in today's talk. So let's start my today's talk. My PPT is visible or not, ma'am?
Please put a slideshow. Yes, put it
on. It is on slideshow mode.
No, it isn't.
Vivek, can you please press F5?
So it is in slideshow mode.
No. Try to.
Not yet.
Not yet. Yes. No, Dr. Vivek, please down. You see also their slideshow. So if you can click on it.
Vivek, you can click on the slideshow option that is available.
Mm.
Yes, please.
From beginning, click on from beginning.
Now I think it is visible.
Not yet. Not yet. Something is not working. I don't know why.
Anyway, ma'am, let him continue because the slides are visible when he's doing it.
Okay.
At least the index slide is visible.
Yeah.
It is index slide is visible or not?
Yeah, it's visible.
Okay, fine. Dear attendees, in today's talk, I'm discussing the need of IPs in academia and industries, why we require more IP holdings in academia as well as in industries. Then I will discuss the brief introduction about the patenting, then different geographical reach of patenting. After it, I will discuss how the academia and industries, they can file the patent by using different applications form. After it, I will give some demonstration related to IP, IPRs and IPRs laws in India, along with some IP with a real life example of IPs. Then we will discuss about the trademarks, copyright and geographical indication. And then we will discuss the patentable subject matters and non-patentable inventions at national level as well as at international level. After it, I will show you how you can evaluate whether your idea or any invention is patentable in India or patentable at World Intellectual Property Office of the world. Right after or at the end, I will give you some motivations related to patenting. So here you can see the need of IPs. This slide is visible to all or not? Need of IPs.
Yes, it is visible. It is visible, but please, if you can try once again to click on from beginning. So then you will be sure you will not need to ask me, do I see the slide, you know? Dr. Vivek, do you hear me?
Yeah, ma'am.
Can you try to click on from beginning? It is visible here where your slide is. No, it don't works. Okay, go, continue, please.
It is visible.
The slide is visible,
There are
yes.
okay, ma'am. Okay. There are several key advantages of IPRs in academia as well as industries. Although, if we are adding some IPR cells, or we can say the IPR departments at the academic institution as well as industries, they give the positive impact or positive consequences, or we can say the manifold benefits for the stakeholders. The most important, or we can say the overreaching benefit of these IPR cells at the institutional level are the contribution in improving the national or regional, or we can say the global innovation performance that is eventually leading to a badly needed marketplace product or process. Because in invention, either we are developing any process or any product or both. At the end of this presentation, I will show you my one latest invention where I have developed process as well as process, right? So there are several key benefits for the academic institution as well as for the industries. After the implementation of innovative ideas from the basic research into marketable products is a risky task, or we can say the cumbersome or very expensive process. But at the same time, there are great market opportunities and profit for the industrial partner of the any institution, right? Because if any invention or any idea is patented at a Indian IPOs or somewhere at international level, whether if in which country you are staying or living, so by protecting your idea, you can collaborate with an industry, or you can your institution can collaborate with any MNC company, or by selling your invention to that particular company or industry, the institution, even the institution and that inventor can get the benefits with a reference to the some financial returns, right? And there are some more benefits like if any individual doing some innovative kind of work, he or she can get more collaboration with respect to their idea, or with the respect the with the collaboration of different people who belongs to the same research domain or same field, right? One more thing, if these innovation or IPR related work give a friendly image to the institution, even to the industries, because if any institution or any industry having IPR departments or IPR cell related such kind of thing, that primarily focus on the generating returns or gaining research funds, right? Because after selling any invention or any protected work, any institute or any inventor can get the good funds. It may also contribute to an innovation-friendly image of the academic institution, which then allows differentiating itself from other research institutions and different universities. My friends, by establishing of knowledge transfer offices at the university level or even at the industry level, because if the invention is protected by patenting, then the second phase is the transfer of invention, right? Or commercialization of invention. So by transferring that innovative idea, or by commercializing that invention, so any institution or industry can get the financial benefit for their balance sheet too, because every company or every industry who are listed on the exchange, whether it's NSE or BSE, they are generally three types of companies. One is small cap, medium cap, or large cap companies. And generally in the financial year, we see the 4 quarters. So in every quarter, we can see the profits in their balance sheet, whether it's a Q1, Q2, Q3, and Q4, because this IP work, if you are doing more number of inventions, that means the company increasing their IP holdings, somehow it is directly related to the funds, or we can say it is connected or connected with the balance sheet of that company. Because if any company is enhancing their IP holdings, somehow directly, or we can say that indirectly, they are increasing their financial capability or financial funds in their balance sheet too. Or in simple words, we can say these all are the things can be reflected in their balance sheet. Similarly, if you talk from the perspective of academia, if any universities are getting more number of patents, so the main significance at the, if you talk from the perspective of India, that kind of university can get good projects from reputed organizations, whether it's a government organization, whether it is a private organization. And the other benefit of any academia is they can get good ranking or good affiliation with different grading or different ranking organizations in India or at international level too. Here in this slide, you can see all the researchers are associated with the academia, you can see, and all the entrepreneurs are associated with the companies, and all the policy makers that are the part of government. So here you can see how the knowledge flows in between these three, and how the economic flow in these three. Here you can see. So this figure basically demonstrate the flow of knowledge and flow of economic in between academia, in between industries, and in between government. It's a general. Here, as I am a student of communication engineering, here you can see the 4G, 5G patent holders as per 2021. Here you can see on the China. China is holding nearly 22.11% stake in 4G and 5G patent. Then on the second rank, we are having South of Korea, then Finland. And on the fourth position, we are having USA, that is having nearly 15.77 4G and 5G patent holders. So these are the top 10 players of 4G and 5G patent holders. Here you can see the different companies shares of global 5G technology patent. Here you can see on the top, Huawei is on the rank 1, then, or we can say that a joint collaborative work of Alcatel-Lucent. Then we are having Qualcomm, LG, ZTE, and so on. Here you can see from the perspective of communication industry, why the patent are important for an industry, right? My friends, if you talk or we can consider the example of any smartphone here, you can see this smartphone, single smartphone contain nearly 3,500 to 3,800 patents in a single smartphone. So every company who are manufacturing such kind of smartphone having nearly 3,500 to 3,800 IPs in their portfolio only by a single design of smartphone. So now you can imagine after selling huge number of quantities of that particular design of that cell phone, they are earning a lots of money. Now come to the introduction part of patent. My friends, patent is an absolute legal right which is government by the inventor, by their uh, governments, or in which he or she belongs to. Suppose as I am belongs to India, so if I'm filing my patent and after the some rigorous process of examination, somehow my work is patented in India, then I will got the some disclosed certificate where my invention is enforceable within the territory of India, right? And if I am filing my patent in India, it will be only enforceable for a limited period of time, that is 20 years in India. And this time period is very as per the different rules of different countries. For example, in Australia, New Zealand, USA, and in China or India, the enforceable time period is different, right? If I'm filing my patent in India, in that case, my invention, protected invention is only enforceable within the territory of India. If I'm filing my invention in the Australia, in that case, my invention or protected invention is only enforceable within the territory of Australia, right? Here you can see if anybody have any innovative idea and that idea satisfies
Dr.
these
Vivek,
three
please.
conditions.
I apologize. Dr. Vivek, please. You are still on the slide. Need of IPS. Can you move?
Now it is
Yes,
visible.
yes,
Okay.
yes, yes, yes.
Shall we start like this?
Okay.
Okay. So if anybody is having any innovative idea, and in that case, that idea satisfies these three essential conditions. First is novelty, second is inventive step, and the third is industrial applicability. So after satisfying these three conditions, in that case, that inventor can prepare their techno legal draft for the filing of the patent. And after completing the by some necessary forms, he or she can directly file their invention for the patenting at Indian IPOs through online mode or offline mode. If it is accepted at Indian IPOs or some other IPOs of the world, in that case, that inventor or signee get a mutual agreement for 20 years in India, and after patenting or after getting the grant of that patent, he or she can sell their invention, they can commercialize their invention, they can go for the technology transfer, right? One more condition, if anybody is filing any patent, he or she must disclose every minor or macro detail about their work. Because if they are not writing any small or micro details about their work, in future anybody can take the advantage of that. So don't miss any small things related to your work. Now come to the geographic reach of patent. Patents are limited to territory. Basically, if you are filing your patent in India, then it is only enforceable within the territory of India. If anybody wants to file or wants to protect their idea at the global level, in that case, that person directly file their patent at the WIPO, WIPO, World Intellectual Property Office. There are different fields of invention. It can occur in the field of science and technology. It can be from the engineering field, or it can take place from the medical field or biotechnology field, nanotechnology field. So invention can take place from in any field of knowledge, or in short, in general, we can say invention can occur from a small safety pin to a satellites. Now come to the patent application. My friends, there are different kind of application. So as per your work, as per your convenience, you can choose out of this any one application during filing the patent. First, we are having ordinary application. In ordinary application, we are having two applications. First is provisional specification application. The second is ordinary complete specification application. My friends, if you are having any idea, but your work or experimental work is not complete, right? But you want to protect your idea. In that case, you can choose first application, that is provisional specification application, right? By for the filing of your idea by using provisional specification application, you will get 12 months time to complete your work. But if somehow you are unable to complete your work in 12 months, in that case, after the completion of 365 days, your application will be rejected at patent office, right? And the second case is complete specification application. My friends, if you are having any idea and your experimental work is everything is complete and you are having your product in your hand, right? And after the completion of your work, you can choose this application, that is ordinary complete specification application, right? You can file your patent using this application. Next, we are having convention application. If you are file, if you want to take the advantage from the priority date, in that case, you can choose convention application. Next, we are having PCT international phase application and PCT national phase application. If you can directly file your patent at global level in World Intellectual Property Office directly by visiting their website, or if anybody is belongs to India or from any other part of the country, in India we are having we can indirectly file the patent at YPO by using Indian IPOs, or we can say by using Indian Patent Office. So everyone having two methods. He or she can directly file the patent at YPO, or he or she can go through the Indian IPOs too. Next, we are having patent of addition application, right? My friends, if anybody is already submitted some application at a patent office, and after few days, he or she realized that he or she want to change or he or she want to do some improvement or some modification in that work, in already submitted work. In that case, he or she can choose this application, that is patent of addition application, right? And the last is divisional or parent application. If anybody is already submitted an application in which he or she submitted two or three ideas in a single form, but after a few days, he or she realized that they want to separate it from that application. In that case, he or she can choose this divisional or parent application. By using this, they can separate out two invention in two different forms, right? In PCT is a patent corporation treaty. In it, there are total 156 countries. They come together. They have a MOU. So if you are filing your patent at a YPO, your patent will be enforceable in 156 contracting countries. Now come to the IP. My friends, intellectual property, or in short, we say IP. It is nothing, it's a creation of human mind. If you are having some innovative idea and your innovative idea have some financial returns, right? Whether that idea is any industrial or scientific or literally or artistic works. So all such kind of work is an intellectual property, because these all are the creation of human brain. Next, we are having IP rights. In short, we say IPRs. These are the some legal rights which is granted by the government to the owner of that invention, right? By getting IPRs for that innovative work, nobody can use that invention without taking prior permission from that inventor, right? This IPR can be assigned or licensed for the financial benefits to that inventor. Here you can see, if you talk about the India, there are Controller General of Patent, Design and Trademark, that is generally taking care of all such things. Here you can see the first is the Patent Act 1970. If anybody is having some in or making any some process or some product, in that case, that work or that invention will be registered under the Patent Act 1970, right? Next is Trademark Act 1999. If anybody is developing any logo, any slogan, or any any such kind of trademark related work that will be registered under the Trademark Act 1999. If any student or any experts belong to the electronics background and he or she is making some semiconductor integrated circuit layout design or developing any IC design, such kind of work will be registered at SICLD Act 2000, right? Next, we are having GI, Geographical Indication of Goods, Registration Protection Act 1999, right? If any product is famous from any particular region of the country, that famous product is registered under this act. The people from a group of people from that particular region of that country, they can register their product under this act. Next, we are having Design Act 2000. If anybody is making any two-wheeler design, four-wheeler design, or making a design of any AC, such kind of geometrical kind of work will be registered under the Design Act 2000. Next, we are having Copyright Act 1957. If anybody is writing any book or doing some artists or creating any artistic or literary work, or if anyone belongs to the computer science engineering background, if anyone is writing code or developing any algorithm, such kind of coding work too can be registered under the Copyright Act 1957. So these are the some important IPR laws in India. This is the basic demonstration of intellectual property. Here you can see, this is the one example of pressure cooker. If we talk about the conceptual feature of this pressure cooker, that can be registered under the patent right. If we talk about the manual or booklet of this pressure cooker, that will be registered under the Copyright Act. Next, here you can see the logo of this pressure cooker, or we can say this is the example of trademark. Such kind of names and logos of that will be registered under the trademarks. If we talk about the geometrical shape of this pressure cooker, or we can say the design of this pressure cooker, this will be registered under the Design Act. In the same way, in the same series, we are having one more example of cell phone. Here you can see. If we talk about the working principle of this cell phone, this will be registered under the Patent Act. If we talk about the design or the shape of this cell phone, this will be registered under the Design Act. If you talk about the name, here you can see there is some name written on the here you can see. So this is the trademark and it will be registered under the Trademark Act. If we talk about the manual or the booklet of how to use this cell phone, this will be registered under the Copyright Act. These are the some IPOs offices. Here we can see Plant Protection Variety Farm Right Act Registry Office situated in Delhi. Then we are having Semiconductor Integrated Circuit Layout Design Registry Office situated in Delhi. Then Rajiv Gandhi National Intellectual Institute of Property Management Office situated in Nagpur. Then we are having for patent office in India, and the head office is situated in Kolkata, you can see. And then we are having Delhi, Chennai, and Mumbai. So as per your convenience, you can choose any one of these four. Next, we are having design wings. The design wing or design registrar office, or having only one office in India. This is situated in Kolkata. Then we are having trademarks registry office. They are in Mumbai, Delhi, Kolkata, Chennai, and Ahmedabad. The main head office situated in Mumbai. Then we are having GI registrar office in Chennai, National Biodiversity Authority office in Chennai, registrar of copyright offices in Delhi. So as per your convenience, you can choose any one of these which is near to you, or you can directly go through the online portal. Now come to the property. My friends, properties are also of two types. One is tangible, other is intangible. My friends, you can see tangible properties, you can sense the tangible property, you can touch, you can see tangible properties. And further, tangible properties are of two types again. First is movable tangible properties, and other is immovable tangible property. If you talk about the laptop, if you talk about the mobile phone, if you talk about the any two-wheeler or four-wheeler, these all are the some example movable tangible property. We are having immovable tangible property like a house, land, flat. These all are the immovable tangible property. Here, both movable and immovable tangible properties, you can see them, you can touch them, right? But in case of intangible property, you cannot see them, you cannot touch them, because These are the creation of human intellect, right? All the intellectual properties are intangible properties. Next, here you can see some trademarks example. All the sounds, letters, words, names, numbers, expressions, logos are the example of trademarks. Here you can see different letters, GM, BPL, Fiat, Beta, Intel. These are the letters trademark. Then we are having Apple idea, words trademark. Then you can see names trademark, Usha, Tata, Ford, Samsung, Nikon. Then we are having one number trademark 4711. It's a famous perfume brand of Germany. You can see. Then we are having expression trademark, that is LG, Britannia. And at the last, we are having some logo trademarks like Mercedes-Benz, Nestle. This is the Oxford University logo. So this is also one example of logo trademark, right? Here you can see some more example of trademarks. You can see Adidas, Google, Microsoft, IBM, Walmart, right? There are so many example, Oreo, SR, LG, Levi's. There are a number of trademarks available in this slide. You can see one more thing related to trademark. If somebody is writing Microsoft like this, soft and micro, he just replacing the word. He or she is writing first soft and then micro. So such kind of modification is also not acceptable at trademark registry office. If someone is rewriting Walmart like Mart Wal, so this is also not acceptable at trademark office, right? So take care take care of such kind of things. Next, we are having copyright. My friends, all the literary and the artistic work is the example of copyright, or we can say the this is registered under the Copyright Act. Here you can see architectural work. Any if anybody is making any song or recording any movie or making any video, if someone is writing any book or a novel, so such kind of work will be registered under the Copyright Act. Next, we are having geographical indication. Here you can see some national example and some international example. If Darjeeling tea is associated with the West Bengal, Mysore silk is associated with the Karnataka, Kullu sol is associated with the Himachal Pradesh. There are so many examples of national GI indication. Here you can see, if you talk about the Darjeeling tea, the group of people from the West Bengal, they have registered for the Darjeeling tea. Next, we are having Mysore silk. The people from the Karnataka, they have a GI for the Mysore silk. Here you can see one Pithani weaving or Darjeeling sea on this slide. We can see some international example of GI. Here you can see Havan cigar is associated with the Cuba, Scotch whiskey is associated with the UK. The peoples from the UK, they have registered under GI Act for the Scotch whiskey. Tequila is again associated with the Mexico. The peoples from the Mexico, they have registered the tequila under the GI Act of Mexico. Then we are having Swiss knife. So the people from the Switzerland, they have taken GI for the Swiss knife, right? So there are more example of national as well as international GI indication you can see. Next, we are having patentable subject matters. If any invention that is very related to a process or product or both, and it is novel and it involves some inventive step, or we can say it is non-obvious, and it has some industrial use, right? And the last, that is very important, it does not fall under section 3 and 4 of Patent Act 1970. In that case, that invention must be patentable at Indian IPOs. Now, understand what is new means in patenting. New means your work is not published in any research paper, in any scientific reports, in any government's reports, on any portal of government or any private organization. It it is not in any public domain, or nobody knows about your work. In that case, your work is new. And the one more thing, that is you must check at the patent website whether your work is already in any claims invention already that are granted at Indian IPOs or in some other IPOs of the world. Now come to the invention. A features of an invention that involves technical advancement as compared to the existing work, or that has some economic significance or both, and makes the invention not obvious to a person is skilled in that art, right? So take care of this. if you are filing patent. Now come to the non-patentable inventions. As per Section 3A Patent Act 1970, all the frivolous inventions or invention contrary to well-established natural laws are not patentable in Indian IPOs or even in the IPOs in the patent office of other countries too, right? If somebody is making any machine or if that giving output without taking any input, so practically this is not possible. Next example, merely making one piece or article previously made in two or more pieces is frivolous. So such kind of work is not patentable under Section 3A. Next, we are having Section 3B of Patent Act 1970. Commercial exploitation or primarily use of inventions which could be contrary to public order or morality. So such kind of work or will not be patentable or not acceptable at a patent office of any country. We can take a few examples for this. If anybody is doing human clothing or if any expert or any student developing some device or method for committing theft or burglary, right? We can take some real life example. If any student making any device by which he or she can do the cheating during examination, so such a kind of invention or such kind of work will not be acceptable at patent office because it is somehow contrary to morality. If any invention that cause serious prejudice to health, human, animal, plant life, or even it negatively affect to the environment or life cycle of the environment. So such kind of work is not acceptable at patent office. For example, if anybody is making any method or device for adulteration of food, because if anyone is consuming this such kind of food, it may cause to some serious disease. If someone is making any method or device for mass destruction of plants, animals, so such kind of work is not acceptable at patent office. Next, we are having Section 3C of Patent Act 1970. Only a discovery of scientific principles or formulation of an abstract theory or discovery of any living thing or discovery of non-living substance occurring in nature, right? For example, Newton's law, Darwin's theory, discovery of an animal, discovery of natural gas or a mineral. So such kind of things are not patentable under Section 3C. My friends, there is a small difference in between discovery and invention. In discovery, we are basically finds the new thing which are already present in the nature. But in invention, we finds the new things which are not present in the nature. So this is a small, or we can say a thin line difference in between discovery and invention. Next, we are having Section 3, substance obtained by mere or admixture resulting only in the aggregation of properties of the component thereof or a process of producing such substance. For example, if we are mixing paracetamol with brufins, then it become a combiflin. Paracetamol have some antipyretic reaction and brufen have some analgesic function. So if anybody is taking patent for combiflin, it will not be acceptable at patent office. But a mixture that result into some synergetic properties of mixture of ingredients, however, may be patentable. For example, soap, detergent, lubricants. So such kind of work are patentable under Section 3. Now come to the Section 3H of Patent Act 1970. Method of agriculture or horticulture are not patentable. Cultivation of algae, mushroom, or any other crop are not patentable. Preparation of an improved soil are not patentable, right? But all the agriculture equipments or tools are patentable, right? If any farmers are developing some process or any farming practice by which he or she can increase the yielding capacity of a farming field, that will also not patentable at patent office. Next, we are having Section 3F, mere arrangement or rearrangement of duplication of known device, each functioning independently of one another in a known way, are not patentable, right? We have two examples for this: a bucket fitted with torch. Here, bucket working independently and torch is also working independently. Both are having no relation because bucket is used for the storing the liquid, torch is used for the lighting purpose. So both are working independently to each other. So these such kind of work are not patentable. For this, we are having one more example, an umbrella with a fan. Umbrella have their own role, fan have their own role. So both are working independently. So such kind of work are not patentable under section 3F. Next, that is IP and self-evolution of invention, right? If you have any idea and how you can evaluate whether it is a which kind of IP is related to your idea, right? If you have any idea and you can express that that is a copyright IP. If you have idea and that idea have some innovation or invention that is related to patent, if your idea have some quality as well as some identity, then it will be a come under the category of trademark. Next, if your idea have some appearance or it have some geometrical shape, right? So it come under the category of design. Next, if you are having some business idea and you don't want to disclose it with your any friend or with anyone, right? In that case, you can keep your idea confidential under the trade secret, right? Your business idea will be protected under the trade secrets. These are the general process of patenting. First phase is publishing of your invention, your idea. And the second phase is examination. After publishing your idea, your idea will be go through a process of examination. For this, you will get some questions or some objections by the controller of examination. After if you are able to satisfy or you are somehow you are completely satisfied the examiner, in that case your invention will be granted, and after the granting you will get a grant certificate in your hand, in which you will get a 20 years mutual agreement in between government of India. If you talk about the if you talk from the perspective of India, you will get a mutual agreement in between the inventor and the government of India. If you are a grant if you are having your patent from the Australia, in that case you will get a mutual agreement in between government of Australia and the inventor, and that work that is enforceable for the 7 years in Australia. And the last process of technology transfer or the idea transfer, or we can say the commercialization. In this phase, you can sell your idea or you can sell your invention, right? These are the top 10 players of academia. You can see. Now come to the drafting and application process. There are two modes of the filing of patent in India or any other part of the country. Either you can file your patent directly through online portal, or you can directly file your patent through offline modes. Generally, there are 4 draft files which you have to create during filing the patent. First is description file, that is file number 1. In description file, you will describe everything related to your invention. Next, we are having figure file. In figure file, you will include all the figures, whether it's a flow chart or any block diagram or related to or any geometrical shape which is related to your idea. You will include each figure in this file. Or you can cite all the figure in your file number 1, that is description file. You will cite or you will write this detailed description about the all the figures which you are making in figure file number 2. Next file is claim file. In claim file, you will write claims which you are claiming for your invention. My friends, I'm requesting you or giving a panacea for the patenting. You must write more than 3-4 claims for your work, because if you are writing 7-8 claims and 2 or 3 claims are rejected at the IPOs, somehow on the basis of rest 3-4 claims your invention will be granted, right? And the last is abstract file. Abstract file is related to the abstract of the research paper. Everybody is writing the abstract for the research paper. So this is the essence of your work. You just write 1 or 2 or 3 paragraphs related to your work in the essence form, right? This is the website. If you are belongs to India, you can directly go visit this website and you can file the patent. Now come to the patent advantages and motivations. The main advantage of the patent, it avoids duplication of research, because you cannot duplicate existing work by small modification or small advancement, right? So it also protect from the duplication, right? The patenting also introduce new techniques, or it will do the enhancement, or we can say the advancement of the method of processes, right? So this is a become a uh, very significant things for the industry as well. As it keeps abstract with the latest development in different fields of science and technology, or any field of knowledge, because it somehow helps the academia as well as industry to improve existing technology to produce cheaper and better products for the welfare of mankind. It serves as an indicator for achievements in R&D institution or any industry, that ability of individual researchers also, because it also reflect the potential of any individual researcher in their portfolio or in the CVs. If you talk from the perspective of the any uh, and this, sorry from the perspective of any institution or university, it somehow enhance the rating of institution like NAC, NBA, and some NIRF ranking also. So it play a very vital role for college universities too. This is a small motivation from my side. This is the youngest patent holder. He's a physically challenged boy. He developed a six-pair chess. You can see, if this boy can do some innovative work, why we are not doing? Why we are not doing? Why we are not applying or implementing the knowledge which we are having in our brain? These are the some work which is done by me, and these are the newspaper coverage. Here you can see. This is the one latest invention which is before 2 weeks is granted at Indian IPOs. Here you can see, these are the some newspaper coverage of my granted patents. You can see. These are the some awards and recognition for my work. You can see. So this is all about from my side. Thank you, Professor Nada. Thank you, Sovik
Thank you,
sir, for
Dr.
giving me such a
Vivek.
wonderful
It
opportunity
was
to
it was
sharing my
really
thoughts.
an amazing presentation, amazing speech, very detailed, very informed. We are really honored. We, our audience. So today, all have a chance to learn from the beginning. This was amazing, Dr. Sovik. What you said, our great Dr. Vivek.
Yeah, especially I was looking at the slides when he was discussing each and every section of Section 3A of Indian
Yes.
Patent Act. It is really remarkable how he has elaborated on the non-patentable inventions and how do we make certain classifications. I think in future, Vivek, we can have you on the patent laws as well. We can have a separate session on patent laws and practices.
Sure, sure,
So
sure, sure.
this will be really interesting for those who are landing at new basically to writing patent or something of that sort. So this is of course it was I had listened to one session on patent laws, uh, but certainly uh, you have included it as a part of your presentation. This is immensely helpful for the listeners, for the participants as well. Thank you
Yes,
so much, Vivek.
yes, Dr. Vivek, and this is really very
Thank you,
motivating
ma'am. Thank
and
you, sir.
giving a inspiration. You know, you inspired our audience, our educators, because everybody thinks that it is a hard job. Yes, it is a hard job, but when you want to do something, when you want to achieve something, you will do that. So if our great Dr. Vivek can do this, and so young, so full of knowledge, so full this work, I'm sure that people are very inspired, and as you say, and show us a little, you say a little project, but every project is a big project, because for the easiest, for the smaller, we also have the same steps. So that is like we want to apply for some grant. It is the same way of application. Even you are trying to get $1,000 or hundred or I mean 10,000 or something like that. The process is the same. Thank you. I'm really inspired very much today. An amazing session. Great. Yesterday also, our great Dr. Sovik make a great speech and presentation. Today, we need to thanks to our great Sir Piyush Pandit, for our founder, for giving us this opportunity. I want to thanks again to great Dr. Sovik for this initiative, for making this second technical symposium. I mean, first in this year, but last year we have a great technical symposium. Dr. Vivek was also with us last time on the latest trends. It was really awesome. So we come to the end of our session. Dr. Vivek will see if you have any questions after. He can also answer because he cannot speak and give you the answers. And also you can be free and contact him in every moment. He's very, I can say he's a very helpful person, and he's ready to help you. And today, sharing the knowledge, sharing the experience with all of us. Tomorrow, third day, dear audience, we are inviting you to be with us. Thank you. Thank you for your presence. Thank you for your valuable messages in the chat. Your support means to us a lot, because with you, this event will not be, I can say, the same. So please, till tomorrow, continue learning and growing, sharing, reflecting. And yes, after this, see me again. We will celebrate Europe Day. Thank you. Thank you so much. See you. Our great Dr. Sovik is today with us. He will also be tomorrow with us with our great new expert. So many blessings, and see you tomorrow and later.